where an event or an offence or an act takes place outside of the workplace, it doesn't follow automatically that an employer is allowed to consider that adequate for a dismissal or even disciplinary proceedings.
It's an HR nightmare in many respects, you might think. Hina Belitz is a partner in employment law at Excello. We can speak now. Good morning to you.
Good morning.
That lack of clarity, that clear example of one person saying, another two people saying, that makes managing something like this very difficult, doesn't it? If someone comes to you in May saying this happened between a presenter and my child, is it clear what an employer is supposed to do?
Well, absolutely. And I think just to go back a bit and to support what you said, the hallmark in my experience of these sorts of matters tends to be quite messy. They tend to be confused and the evidence doesn't always stack up. I don't think I've known a case which is neat and obvious, because in such a situation you wouldn't really have this sort of media furor. So yes, an obligation of an employer is quite clear. It is essential to investigate thoroughly and carefully. And I think the thing that's being missed or that people are becoming aware of is that social media is a runaway train. And what tends to happen is a lot of pressure is applied on coming to a conclusion or revealing information before a proper investigation has taken place. And the BBC have a legal obligation to investigate properly and thoroughly. Now, as for the delay, as Alex mentioned earlier, there's a lot of questions that remain unanswered. So we don't know what they were aware of at that point and whether they were in fact investigating at that point or whether there was some sort of delay in the investigation. The obligation of an employer absolutely is to investigate immediately. And then the suspension is an important point, because a suspension is not a disciplinary sanction. It should not be disciplinary. In other words, it should be on full pay, because it is not designed to be punitive or punish anyone. At this point, it's designed to create space and avoid any further wrongdoing, if there is wrongdoing, from taking place, and enable an employer to investigate thoroughly.
And how much is a suspension itself a public act? I'm interested in this, because once you suspend someone in any job, it becomes known to colleagues because the person is no longer there. And in most companies, when someone gets suspended, nobody cares. It's not being reported all the time. In media companies, and this is true of all media companies, it becomes known. So does the act of suspension change the privacy aspect of what is going on in a media company, do you think?
I mean, that's a really excellent question, because you're absolutely right. In most situations, certainly that I deal with, the suspension is not too important, or at least most people don't really, they may not even know. They may think the person's on leave or unwell or something of that sort. So there's no effort to share that. But this is so public, and it does change things. There are arguments, definite arguments, that damage is already being done just by virtue of a suspension, and certainly by virtue of the discussion and views being held across the board through social media. So yes, there's no doubt with the high profile nature of the BBC, the high profile nature of the individual in question, there are dimensions that simply would not ordinarily apply to an employer.
And might argue slightly against privacy, because you suspend someone and therefore action has been taken, and therefore it's harder to say this is private and no one should know about it.
Well, look, absolutely. The law does provide, I mean, certainly I'm an employment law expert. The law provides for the right to anonymity in situations where there are sexual allegations and in certain other situations. But certainly in this case, it's almost impossible to truly have a situation of anonymity to the extent that you would have elsewhere. Certainly when you're facing an employment tribunal, you can ensure that reporters that may be present are not permitted to indicate or name an individual, because of that very fact that if someone is smeared, that even if they are completely innocent, the damage can be done. And and the smear, even if they are ultimately proven to be completely innocent of the offences,
Yeah.
they can still be considered to have,
Yeah.
their career.
Yeah, exactly. People see the damage done. Just finally, before you go, how much is it incumbent on a company? Say this action that's being talked about. This is sending money to an individual in return for inappropriate pictures. If that doesn't take place in using office equipment, if it didn't take place in office hours, does the employer have the same right to be punitive in response to it? Is it still a matter for the employer?
That is a really excellent question, and actually it's very key in this situation, because in fact, where an event or an offence or an act takes place outside of the workplace, it doesn't follow automatically that an employer is allowed to consider that adequate for a dismissal or even disciplinary proceedings. So what can happen is that there are instances where an employer has thought, well, someone has been guilty of doing something, or they believe that they're being investigated for something which is serious, and then they take action inside the workplace. And that dismissal, which ultimately results, can be held to be unfair. So the two don't automatically connect. There are times when they evidently do, but there is ample case law to support
That's
the fact
interesting.
that people don't necessarily have to, employers don't necessarily have to take the acts outside of the workplace to just make a decision internally within the workplace.
Really interesting. Hina, great stuff. Thank you so much for joining us today.
Thank you.
That's Hina Belitz, their partner in employment law at Excello.